Hello everyone, my name is Fion. So today we will be discussing a complex but timely issues involving international treaties law, environmental responsibilities, and also evolutions of legal norms. This case involves a treaty between two states, State Aramika and State Bothuna, who built a dam together on a shared river. So after a decade of cooperation, State Aramika suspends the treaties unilaterally, claiming that State Bothuna repeatedly failed to follow environmental safeguards. It argues that this is a material breach under Article 60 of the Vienna Convention on the Law of Treaties 1969 VCLT. So, after that, State Bothuna quickly fires back, saying that the safeguards are actually outdated due to climate change. It invokes Article 62, which covers the rebus stantibus, arguing that a fundamental change in circumstances justifies the terminations of treaty. On top of that, State Bothuna cites a recent UN resolution recognizing access to clean water as a Jus Cogens norms. It claims that the dam now violates these higher norms, which would void part of the treaties under Article 64. This scenario raises three critical legal questions. So first, is State Aramika legally justified in suspending the treaties unilaterally? And second, are State Bothuna's defenses under the VCLT credible and sufficient enough? The third one, which is a more broadly one, can environmental principles evolve into Jus Cogens norms overriding treaties in the process? So today, we will focus on these questions in the context of relevant treaty law principles, international jurisprudence, and also together with scholarly commentary. So now, let's get started with the first issue. So, the first issue is whether State Aramika was legally entitled to unilaterally suspend the treaties on the grounds of a material breach by State Bothuna under Article 60 of the VCLT. So, under Article 60, subsection 3, clause B, a material breach includes the violations of a provisions essential to the accomplishment to the treaty's object and purposes. So now let's apply it back to our case. In the context of a joint dam project on a shared river, it is reasonable to consider that the environmental safeguards are not merely technical obligations, but central to the treaty's integrity and long-term function. And therefore, State Bothuna's repeated failures are to undermine these safeguards, which amount to a violations of the object and purposes under Article 60, subsection 3, clause B, together with a repudiations of the treaties under Article 60, subsection 3, clause A. And therefore, State Aramika is justified under Article 60, subsection 1 in suspending or terminate the treaties either in whole or in part. These two cases are especially relevant in illustrating how a material breach under Article 16 may justify suspension. So first, in the Namibia Advisory Opinion 1971 case, the ICJ upheld the terminations of South Africa's mandate as its conduct violated the essential purpose of the agreement. Similarly, in our cases, State Bothuna's continued failure to uphold environmental safeguards may be seen as a violation of the treaty's main goal and therefore supporting State Aramika's decisions to suspend. Secondly, in the Hungary and Slovakia 1997, ICJ court as well recognized that a material breach, such as failure to meet critical environmental obligations, could justify suspensions under Article 60. Likewise, State Aramika invokes State Bothuna's environmental non-compliance, aligning with the court's approach to assessing breach based on the treaty's environmental objective. We now examine State Bothuna's possible defense. First, under Article 62 of the VCLT, which covers the part of rebus stantibus, a treaty may be terminated if there is an unforeseen, fundamental change that radically transforms the obligations. However, international law applies this really narrowly. Bothuna's claims of climate change itself as a defense is insufficient unless it fundamentally alters treaty's duties and also it does not meet the high threshold. First, the climate change is not unforeseen, as the State Bothuna itself failed to update or to comply with existing environmental safeguards. And second, climate change is not directly linked to the object and purposes of the treaties, which remains joint management and environmental protection. Third, treaty obligations includes adaptations and cooperations, as climate change did not eliminate the possibility of performance. And therefore, climate change does not satisfy Article 62, as Bothuna's claim to terminate the treaties on this ground is unfounded. The Hungary and Slovakia case is the most authoritative precedent where a parties, which is Hungary in this case, specifically invoke climate change and environmental concerns to justify treaty terminations under Article 62. The ICJ court in this case rejected the arguments, ruling on the grounds that, first, those changes are not unforeseeable at the time when the treaty was formed, and second, it is not radical enough to justify terminations under Article 62. Now, let's look at the area chart on your right side, which shows the percentage of global river catchment that experienced below average flow from 2021 to 2023. Based on the data from World Meteorological Organizations, that this is a compelling data to our case. From 2021 to 2023, over half of the world river catchment reported below average flow. So while climate change is indeed a pressing issue right now, however, the data shows that these changes are gradual, not sudden or unforeseen one. This strengthens our arguments of foreseeability. Diana, in her writings in 2021, emphasizes that rebus stantibus should be strictly applied to maintain treaty stability. She cautions that while climate change is serious indeed, it cannot on its own justify treaties terminations. Same, unless it causes a radical or unforeseeable change that fundamentally alters treaties' obligations. Now, we come to the third issue in regards to the powers of Jus Cogens. So what do you mean by Jus Cogens? Jus Cogens covers under Article 53 of the VCLT, and it basically means the norms of peremptory international law that overrides conflicting treaties. However, we should be aware that it subjects to a really high threshold. While on the other hand, Article 64 of the VCLT covers the terminations of treaties due to Jus Cogens, and this only happens when a treaty goes against a fundamental rules of international law. It will then automatically void. And this raises the questions that, does the dam project violates the Jus Cogens in our case? Before we dig into that questions, there is something that we need to discuss, which is what makes a norms become a Jus Cogens and what are the requirements. So first, Article 10 of the UN Charter stated that it only grants United Nations General Assembly UNGA the powers to make recommendations and is not legally binding. So what is this means? Based on the facts, we know that UNGA has recognized the access to clean water as one of the Jus Cogens. However, Article 10 stated that the recognizations made by UNGA can only be served as a mere recommendations and is not legally binding. This is later reaffirmed in the ICJ Advisory Opinion 1962 case, which some resolutions, although have legal weight, but they are not legally binding. And off-topic questions. Can a dam project affect clean water? To be honest, it might have. However, we should also be aware that this alone is insufficient to prove for a breach of Jus Cogens. Now, let's back to the applications of facts. The claims that the dam projects violates Jus Cogens is completely lack of legal foundations, and Article 26, which covers pacta sunt servanda, still applies, which will be discussed later, and most importantly, the treaties in our case remain in force. So now, what is pacta sunt servanda? It is covered under the Article 26 of VCLT, meaning that an agreement must be kept. This reflects the foundations of treaty law, basically means that once you enter into a treaty, the treaty is binding and must be performed in good faith. So while assessing whether a treaty can be invalidated, the VCLT distinguishes between two types of invalidity. First, relative invalidity under Article 46 to Article 50 arises only when there are defects in consents, like for example coercion, fraud, or even errors. These make a treaties become voidable. However, they do not apply in our case because there is no indications of defects in consent between State Aramika and State Bothuna. Secondly, absolute invalidity under Article 51 to Article 53 is a more serious one, as it includes treaties that violates peremptory norms of international law, like for example prohibitions on genocide, slavery, or even torture. And these treaties are automatically void. In our case, State Bothuna's claims of Article 53 under absolute grounds is deemed insufficient, and therefore the treaties remain binding. To support the primacies of pacta sunt servanda, we can refer to ICJ court decisions in the land and maritime boundary case between Cameroon and Nigeria 2002. So in this case, what happened is, Nigeria attempted to argue that changes in political circumstances and fairnesses justify enough to depart from treaties obligations. However, the ICJ court in this case rejected that position, reaffirming that treaties commitment remains binding unless it was properly terminated under the law, which strengthens State Aramika's positions that a party cannot simply disregards obligations due to evolving conditions unless criteria are met. In addition, Catherine, in her writing in 2012, provides a scholarly perspective that reinforces this view, as she argues that Jus Cogens should not override treaties provisions unless there is a clear and direct conflict. Evaluating the scenario, the key principles that emerges is the importance of treaty stability and also legal certainty. So, state Aramika suspensions under Article 60 was not legally grounded, but also aligned with the need to uphold the treaty's object and purposes. This is much like the case of salted bluefin tuna in 2000 years, where failure to meet conservation obligations was seen as undermining treaty's integrity. Turning into State Bothuna's claim under rebus stantibus, the Pulau Linggitan and Pulau Simpadan case in 2002 provides a clear precedence. So in this case, the ICJ courts upheld historical treaties arrangement despite geopolitical shift, emphasizing that mere changes in contexts like, for example, climate change is not enough unless they fundamentally alters the obligations. Regarding the Jus Cogens claim in access to clean water, even if the norm itself is morally compelling indeed, as seen in the North Sea Continental Shelf case 1969, it reminds us that a peremptory norms must show universal state practices and also opinion juries. At this stage, clean water access remain as aspirational norms, not a binding Jus Cogens that capable enough to invalidate a treaty. Now, we have come to our last part, which is suggest reforms. In light of Aramika's and State Bothuna's disputes, several reforms can be considered to strengthen treaties framework in similar contexts. So first, international law should have a better recognition of evolving environmental norms, such as climate change reshape river flows and also energy needs. So treaties like the one between State Aramika's and Bothuna's must account for variability of renewable energy resources like wind and solar. This would help to avoid disputes based on outdated environmental safeguards. And also, secondly, there should be a clearer pathway for identifying new Jus Cogens norms. Like for example, in the Barcelona tractions case in 1970, the ICJ court acknowledged that some rights are considered emerging rights. However, we currently lack of a well-structured process to evaluate this kind of emerging right. Like for example, in our case, the access to a clean water to a Jus Cogens status. A formal UN mechanism should guide this kind of development and reduce ambiguity, unlike the current claim by State Bothuna's, which lack of a clear legal standing. Lastly, we need to emphasize multilateral environmental dispute resolutions mechanism, like in the case of pulp mills case in 2010, where the ICJ court emphasizes procedural duties like, for example, environmental impacts assessment. Applying this back to our case, future treaties could mandate cooperative processes like, for example, arbitrations or joint monitoring to resolve river sharing disputes without unilateral action. Now, to sum this up, State Aramika suspensions is legally justified under Article 60 and Bothuna's non-compliance amount to a material breach. And secondly, State Bothuna's defenses does not meet the high threshold under Article 62 and also Article 53 respectively. Moving forward, the right to a clean water is indeed important, however, is still incapable to override treaties' obligations. Lastly, pacta sunt servanda remains to be the guide principles, as treaties must be respected unless it was lawfully terminated. Thank you.